The person who have the Kia X100, can you please change your name on your phone or your tablet so we know who you are? If you have the problems doing that, just chat me in the chat box and I will change it. Do you know how to change your name, or you can tell me who you are? We're just waiting on the judge to log on, so please be patient with us. We're getting there. Thank you.
Good afternoon, everyone.
Good afternoon, Your Honor.
Afternoon, Your Honor.
Good afternoon, Your Honor.
You're back on mute, Judge. You gotta unmute yourself again.
All right, sticky fingers. Sorry about that.
South Annex, who y'all have?
I'm sorry.
We have position number 3, Ms. Bryant.
All right. Let me do my opening real quick and then we'll get started. Ladies and gentlemen, good afternoon. My name is Judge Regina Mincy, and we are going to begin our Fulton County State Court Expedited Accusations calendar. This is a calendar for cases in which individuals have recently been arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused the cases of the offenses brought against them, and these cases have been bound over to the Fulton County State Court. Nevertheless, this is usually the defendant's first appearance before a state court judge, so we're able to obviously address bond matters today, possible arraignment, and any plea offers if they have been made at this juncture. I'll be providing you with the reset date for SAP. And I want to begin by advising everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube. Also, to the defendants on the calendar, you have certain constitutional rights. The first being the right to have an attorney to represent you at this bond hearing. And most of you do, and you know who your attorneys are by now. Also want to remind you that you do have a right to remain silent. Anything that you say about the facts, the circumstances, and the occurrences of your case can and will be used against you. The solicitors are here listening to you, so govern yourselves accordingly and listen to your attorneys as they instruct you what to do. All right. Okay. First case.
She's position 3 and 4.
3 and 4.
Yeah, at South Annex, she has 2 cases on the calendar.
Okay. Thank you.
Mhm.
That's at the South Annex.
Yes, Your Honor.
Okay, this is Michonne Bryant, case number 22CR004371E, where you charge at 1 count of simple battery family violence with the offense date of June 27th, 2021, I'm sorry. And you have a second case, Ms. Bryant, which is 22CR004372E. That charge is a false report of a crime, and that offense date is June the 29th, 2021. Do you have anything pre-trial?
Fourth arrest, 2013 simple battery dismissed, 2012 simple battery obstruction, and the 08 battery obstruction and simple battery. TV recommended.
And who is the prosecutor on this case?
That would be me, Your Honor. ASG Backus here for the
Backus.
state.
Nice to meet you. I don't think I've met you before.
I don't think I've met you either, but good to meet you, Your Honor.
Okay, you too. Welcome aboard, Mrs. Backus.
Thank you so much.
All right, go ahead.
Your Honor, in this case, it appears that officers responded to a call on June 29th, 2021, to 2423 Martin Luther King Jr. Drive. This is at the Peaks Apartments or Peaks at MLK Apartments. Upon arrival, the officer spoke with both the defendant and the victim, which is the defendant's mother, Ms. Michelle Bryant. Michelle Bryant stated that on Sunday, June 27, 2021, that the defendant hit her sister, Monique Parks, in the face near her eye. She also stated that Monique Parks is mentally handicapped and legally blind. Your Honor, according to Ms. Bryant, all three of them reside in that apartment. She said that prior to this incident, the defendant came to her mother's room. I guess they got into an argument over a cup that was left somewhere that it wasn't supposed to be. And the defendant then kicked in her mother's bedroom door, and she began hitting the defendant began hitting her sister, and the mother then started hitting the defendant to protect her other daughter. Ms. Bryant stated that she called the police, but at the time she didn't tell them that the defendant had hit Ms. Parks. And when the officer asked Ms. Parks what happened on that Sunday, she stated that her mother was the one that was hit in the face, and that the mother's hair was pulled, and she pointed to the defendant as the one who did it. She also told the officer that the defendant told the officer that she kicked the door in, her mother's bedroom door in. And when the officer was there, he did observe that the door was repaired, but the defendant admitted it nonetheless. And she also admitted to having the physical altercation with her mother, but she said she never hit her sister. Your Honor, just because of the violent nature of this offense, there's 4 cycles, but there's a battery and simple battery from 2008, an arrest, an obstruction and a simple battery in 2012, an arrest, and a 2013 simple battery. So she has a history of violent offenses and not being able to refrain from engaging in violence. And so the state's recommendation is a $2,500 surety bond on 2,500 surety, a stay away from the incident location, the no further violent contact with the victim, and no alcohol, drugs, or weapons, and 1-day anger awareness. Nothing further, Your Honor.
All right, your recommendation was no further violent contact and no.
It should have been no further contact.
No further contact.
That is correct, Your Honor.
All right. And Ms. Gant, is this your case?
Yes, Your Honor, thank you. Miss
Okay.
Michonne Bryan is 35 years old. She has been in the Atlanta, Georgia area her entire life. She has a 19-year-old daughter. She also has additional family here, therefore she has community ties. Miss Bryant completed high school. She is currently employed at MAC 2. She just started this job back in June. And Your Honor, this is how she learned of the warrant. She turned herself in upon learning about this warrant for these allegations that occurred back in 2021. My client denies the allegations, and we heard that my client has been arrested. However, she has not been convicted. And Your Honor, I would ask that you not rely on any arrests that have not led to convictions, Your Honor. She is recommended for a signature bond. I am requesting a signature bond on her behalf for the simple battery family violence. Your Honor, we are unopposed to the no contact order. Ms. Bryant informs me that she does not want to have any contact with her mother. However, we are opposed to the stay away, as Ms. Bryant informs me that the incident location, her mother moved out in February of 2022, and that is in fact Ms. Bryant's residence. Your Honor, thank you.
Okay. I have any victims on the line for this case? And let me also ask the question to clarify, Ms. Backus, is the victim is Michelle Bryant, and is it Monique Parks as well, or just?
So per what Ms. Park said, she only talked about her mother to the officer. And so she's only being charged for simple battery against her mother.
Which is the Michelle Bryant.
That is Michelle Bryant, correct.
All right, I'm going to, and let me look at one more. Hold on one second. All right, I'm going to go ahead and enter the $2,500 surety bond. I'm going to order that there be no further contact with the victim, Michelle Bryant. And I wish we had some information on this location before I order the stay away.
And our office did attempt to contact, and we were unable to.
Right. Usually what I try to do is to say that there will be a one-time law enforcement escort to go back to that property, to that address on Martin Luther King. And if it appears with the officers there with Ms. Bryant that your mother has moved out of that location, you can stay there. If you go back with your escort, police escort, and your mother still has belongings there where it appears that she resides there, then you cannot reside there and you will need to find somewhere else to live. Don't like saying it that way because it's confusing, but Ms. Gant helped me out on this a little bit. Is it clear that the defendant will go back with the police escort to either retrieve personal items if it appears her mother still resides there?
Your Honor, I just found a note that says she did leave there. The mother did leave.
Okay, all right. Well, then I will not do the stay away. I will remove that condition. And the only condition would be no further contact with Michelle Bryant. No drugs, alcohol, or weapons while on bond. And I was tempted to add in Monique Parks as another victim, but I will not do that at the moment. But I hope that Ms. Bryant, you will not have any more contact with either party so that you don't wind up back here in the Fulton County Jail, okay?
And Your Honor,
Your Honor, if you're,
clarify,
go ahead. My
I
apologies.
have a question about the bond, Your Honor. Did Your Honor order a signature bond or a surety? She is recommended for a signature bond.
I did a surety bond. I didn't see her recommended.
According to, I believe that I heard Mr. Toussaint state that she is recommended.
Your Honor, I believe that pretrial did say that as well, but I also, based on her record and the fact that she has had so many simple battery charges, or I'm sorry, not charges, she's been arrested, so many simple battery arrests, Your Honor, we're still asking for the $2,500 surety. And Your Honor, I'm not sure if I got this on the record. Did I add the one-day anger awareness? The state is seeking that as well.
I'm not gonna order the one-day anger awareness unless I was doing it through pretrial. I am concerned as well with her record and with the fact that she seems to, she seems to have some anger management issues or allegations of it anyway. I won't order the course at this point, but I'm going to leave it as a $2,500 surety bond.
And Your Honor, if I may, I do respect the ruling. I would just bring to the court's attention, Your Honor, that again, no convictions, and the last encounter is 2013, almost 10 years ago. And this incident is alleged to have occurred in 2021, which is a year ago, and we have not heard about any further instances or any arrests since then. So I would ask that you consider, please, giving her a surety bond. She just started work. She doesn't have the means to bond out.
I think you said, please give her a surety. Please.
I mean, I'm sorry, signature bond. Certainly, I'm not recommending that, Your Honor. I do apologize for misspeaking.
Okay. Kyle, are you still with me? Mr. Toussaint,
I'm here.
okay.
Oh, you need me?
I was just gonna ask, she is recommended?
Yeah.
Your Honor,
I mean, just set a high bond. If you give a pretrial, just set it high.
I am, and I was getting ready to say that, I was gonna raise it, and Miss Backus, did you have one other thing to say?
I was gonna say that the court had ruled, and please respect the ruling, but you, I'm not sure what's happening now, so I will defer to you.
All right, although the court has ruled, I will take into consideration the time frame and the fact that this was a 2021 incident, and there appears to have not been any incidents, and maybe because the parties have obviously moved apart, the victim has moved, and maybe they have eradicated some of the issues that are going on. But what I'll do is I'm going to make it a $4,500 signature bond. Sorry to be confusing, Ms. Lewis. A $4,500 signature bond through pretrial. And I'm going to put back in a one-day anger management course through pretrial. No further contact with the victim, Michelle Bryant. No drugs, alcohol, or weapons while on bond.
And what about the second case?
Now we'll start with the second case. And is this is a different date, but is it related to the first case factually?
Yes, Your Honor.
Same victim?
Well, this is a false report of a crime.
Okay. Go
So,
ahead
Your Honor,
on this one.
so in this case, and this is the same day, officer responded the same day. And so upon arrival, he met with the defendant. She's actually the person who called the police. She stated that approximately 30 minutes prior to the officer's arrival, her sister, who is McCole Hall, came to that location and pointed a gun at her because Ms. Hall was upset that the defendant had a physical fight with Ms. Hall's daughter. And so the defendant then said that while Ms. Hall was in the parking lot, she yelled for the defendant to come outside. So the defendant came onto the balcony. At that time, Ms. Hall allegedly began calling her names and walked up near the balcony and pulled out a gun at her and said she was going to shoot her and that she would kill them. She said at first the gun was pointed directly at her. Then she said Ms. Hall lowered it and pointed it at her legs. She gave a description of the gun to the officer. She said it was possibly a 9mm with a red beam. While on the scene, the officer spoke with Michelle Bryant, the defendant's mom, and she stated that she's the mother, obviously, of all of them. And so her account was that Ms. Hall came to the apartment to drop off Monique Parks, who's the sister from the other case. And Ms. Bryant said she saw the defendant and another female run up to Ms. Hall's vehicle and chase her away. The officer observed a video camera from the building. And I guess at that time, he made the determination that the defendant's story was not consistent with what actually occurred. And so, Your Honor, the state's recommendation on this one is a $1,000 surety bond. And again, it's based on her history, the violent nature, even with her own admission in this story to the officer. She's talking about another fight that she was in with her niece. And so we feel that.
My niece
Please remain silent, Ms. Bryant. Please remain silent.
Please don't interrupt, Ms. Bryant.
All right.
So again, if it's not her niece, it is Ms. Hull's daughter. And so this is what's being said to the officer. So again, Your Honor, based on the history, the nature of the offense, we feel that a $1,000 surety bond on top of what was put above is appropriate. Nothing further.
And then tell me the victim's name in this case is Nicole. Is it Hall or Hull?
It looks like it is spelled Michole. Last name is Hall, common spelling,
Okay.
Hall.
Gotcha. Okay. And she happens to be the sister of the defendant. Is that correct?
That is correct.
All right, Ms. Gant.
Thank you, Your Honor. My client strongly denies the allegations. And again, this false report of crime is not a violent offense. Again, my client does not have a violent history, Your Honor. I am requesting a signature bond. And in fact, regarding Nicole Hall, Ms. Bryant actually asked me to reach out to her sister to help her with her bond. So therefore, I just do not believe these allegations. My client denies them. Therefore, I am requesting a signature bond, Your Honor, through the jail. And if Your Honor determines that she's ineligible, then a bond of no more than $100.
Your Honor, just to piggyback, the mother, I agree with Petey Gant. The mother did say that she doesn't fear the daughter, but at the same time, I never once said that the mother was in fear. My argument is that based on the record, whether they're arrests or charges, she obviously has some type of issue with violent behavior. And so again, the reason why we asked for the $1,000 surety is because above we asked for the surety on the other case. And so the $1,000 surety, we're still asking for it to stand.
Okay. I'm going to, on this case, I'm going to get a $2,000 signature bond, and I'm going to make it through pretrial so that both cases will be monitored through pretrial. And of course, if she violates any conditions, and they will revoke those bonds. So it's a $2,000 signature bond through pretrial. I've already ordered in the other case a one-day anger management course. I don't need their anger awareness, so I don't need to do that. I'm going to have no further, at this point, no further contact with Nicole Hall. And I think I don't need to do a stay away, so I guess we're clear on that. No drugs, alcohol, or weapons while on bond.
Your Honor.
Okay, so that should conclude both cases.
Thank you, Your Honor.
All right, thank you.
Thank you, Your Honor.
Next, we have position 5, Ms. Courier.
Thank you. This is case number 22CR004362G. Carstanthia Courier, you're charged with 1 count of battery family violence with the offense date of July the 7th, 2022. Do you have anything pre-trial?
The 8th arrest. Last was 2017, misdemeanor possession of marijuana conviction. 2012, possession of dangerous drugs on sale, disposition for it. 2012 battery DV. I didn't see the disposition in Odyssey for that one. And before that was an 08 failure to appear for pointing gun at another, possession of a hoax device. 06 possession of a hoax device conviction. That's it.
All right,
She recommend.
okay, thank you. Ms. King?
Yes, Your Honor. We have limited facts for this case. We were not able to receive the incident report in time. All we know is that the defendant punched and kicked her daughter, Deasia Courier, DE''ASIA CURRIER, and the officer noted injuries to her face and her arms. The defendant's criminal history is concerning to the state. While it's only 7 cycles, the majority of them are violent. She has an abusing public school teachers, administrators, or school bus drivers, afraid, disorderly conduct. While it's in 2002, that shows that that's how far her violent arrests go back. She also has a pointing or aiming gun or pistol at another from 2008 that was tied to the hoax device felony conviction. So I'm assuming the device that she was pointing ended up being a hoax and not actual firearm, but the fact that it was even a topic of discussion is a concern for the state. Also, the fact that she has another battery family violence arrest, that's from 10 years ago. The victim in this case is 13. It could have been her. We were not able to confirm who the victim was in that case. But the fact that she has a previous battery family violence arrest is concerning to the state. For that reason, we're requesting an $8,000 surety bond. And as far as the conditions, Your Honor, being as though the victim is a minor, we were not able to speak with her. So we're not sure if no further contact and stay away would be appropriate, because we do not know where she would go. I'm hoping the defense can shine some light on the status of the minor child to know what conditions will be appropriate.
Okay. Ms. Gant?
Thank you, Your Honor. Miss Carstanthia Courier is 38 years old. She has been in the Atlanta, Georgia area her entire life. She has two children, ages 10 and 13. The 13-year-old is the complaining witness. The other is a 10-year-old son. Both children live with Miss Courier, and she is not receiving any child support. Your Honor, we are opposed to the stay away or any stay away orders. However, I did reach out to Shirley Courier. She is the person who is the mother to Carstanthia Courier. She's also the complaining witness's grandmother, and it is my understanding that they all live with Miss Courier. Miss Courier, I spoke to her. She informs me that she does not want to have her daughter Carstanthia to return to the home. Miss Courier gave me permission to speak to her daughter, the complaining witness. The complaining witness informed me that she wants to have contact with her mother, but she doesn't want to live with her mother, Your Honor. Now, moving on with about Miss Courier. Miss Courier completed high school. She has 1.5 years of college. She attended West Georgia Technical College. She majored in early childhood education. At this time, Miss Courier is unemployed, Your Honor. She last worked 3 weeks ago at a variety store. She was scheduled to have a job interview for a new position. So, Your Honor, she does not have the means to pay anything toward bond. I am requesting a signature bond on her behalf. She denies the allegations. We heard from the state that they have limited facts. Ms. Courier offers a competing version. She states that her daughter attacked her initially. She hit her, and that she was basically taking steps to try to calm her daughter down because her daughter was also tearing up things in the house. Your Honor, we heard about my client's history. Again, I would ask that Your Honor not rely on any arrests that have not led to conviction. She's presumed innocent in this open case. Again, she denies these allegations. We would ask that Your Honor enter a no violent contact order, and we are opposed to the stay away. However, in light of what Ms. Courier informed me about her desire to have her Ms. Courier return there, we would leave that to the court's or defer to the court's ruling. Thank you, Your Honor.
Your Honor, in light of this new information, while the facts in the warrant might be minimal, it is reasonable to assume that the police officers did conduct an investigation on the scene, and that is the determination they came forward with. And I believe at this time it would be appropriate to rely on the information from the officer that was on the scene. Furthermore, Your Honor, since there is a grandmother that's present that the victim can be in custody of, we ask that the victim is able to reside at the location, incident location, her home, with the grandmother, and the defendant be given a stay away from that location and no further contact with her daughter.
All right, what is the stay away address?
It is 1797 Willis Mill Road in Atlanta.
All right, I'm going to, given the case and what I've heard here, I'm going to order a surety bond in the amount of $8,000 surety bond. I am going to order that the defendant stay away from the incident location, 1797 Willis Mill Road. I'm going to order that she have no further contact with her 13-year-old daughter. Is it Deasia Courier?
That's Honor.
And I'm going to order no drugs, alcohol, or weapons while on bond. Anything else I need to take up?
Nothing from
Nothing
the
further
state.
from the defense.
Thank you.
Next, position 7, Mr. Fox. He has this is a private attorney case.
This is Katrina. There's no one-time return to pick up her belongings. Normally when you do a stay away.
I'm sorry.
I'm just asking. Is there a one-time return for your personal items at that address or no?
Yes, I'll allow one-time police escort to return to get any personal items from Ms. Courier.
Oh, thank you, Your Honor, and Ms.
All
Lewis.
right, thank you. All right, we are on position 7. Fox, okay, and I see Attorney Michael Barber.
Good afternoon, Your Honor.
Good afternoon. This is case number 22 CR 004374F. Daniel Stephen Fox, charged with 1 count of battery, offense date April the 2nd, 2022. Pre-trial? First arrest? Okay. All right. Ms. King?
Yes, Your Honor. On April 2nd of 2022 at 5100 Avalon Boulevard, that is the Kona Grill restaurant, the accused came into the restaurant to confront the victim in this case, a Miss Jalen Jones, Jalynn Jones, traditional spelling. The defendant was claiming that the victim had made an attempt to sleep with him. The victim denies this and called him a liar. At that point, the defendant got into her face. This is in the middle of a packed restaurant, Your Honor. After they started to argue for a while, the defendant took his hands and shoved the victim in this case, and then he slapped her in the face. At that point, bystanders intervened to grab him and actually escort him out of the restaurant. The manager, et cetera, was asking him to leave and he refused. So it took patrons to actually get him out of the restaurant. When the officers looked at the victim, they noticed a bruise on her lip. Yes, there was a bruise on her lip. And he spoke with many witnesses in the restaurant that confirmed they saw the defendant strike her. While the defendant does not have an extensive criminal history, the violence and the anger is concerning, especially in front of people. There was no care who was watching what was happening. For that reason, the state is requesting a $3,000 surety bond, no further contact with Ms. Jalen Jones, a stay away from the Kona Grill, which is the incident location. I would defer to the court if a stay away from her location would be appropriate, and no drugs, alcohol, or weapons while out on bond.
Tell me this, and I guess I could also ask Mr. Barber for clarity. So the Corner Grill, is that where the defendant works, or does it not?
That is correct, Judge. The defendant works at Kona Grill.
Right. I thought I understood. Yes.
I can elaborate on that when it's my time to shine.
Okay. That was my question. Go ahead. That's a good segue. You may go ahead and present.
Thank you, Judge. The facts that I have are a little bit different. My client was working that day when the alleged victim came in and started the argument. Obviously, the video, since I just learned now that there's video and bystanders that would be able to say if my client was working that day, but I didn't hear that in the soliloquy that was given by the state. Well, let me take that back. What I heard was she was working that day, but what my client's saying is he was working that day. So we got a little bit of a misnomer as to who was working that day and who came up and started this fight. What we're more worried about, Judge, my client, he now has a new job. He works at Miller's Ale House. He goes to church, World Harvest Church. He's active in the ministries there, both children's, the street reach, the teen ministry, and he does a lot with the Atlanta Food Bank. I mean, that alone kind of tells me that this is kind of weird that this outbreak happened. She said no extensive criminal history, but what I heard from pretrial was no criminal history at all. So it's a little disconcerting to me that we've got such a wide gap here, but that means that as the prosecution knows, we just got something weird going on here, and we need to talk with witnesses and get the videos to see who was actually working that day. I think that'll resolve most of this. Based on the information I have, Judge, we were actually going to ask for a signature bond, but at a minimum, what I don't want to have happen is if there's any truth to what we've given today, I don't want this victim coming up to Miller's Ale House and starting this all over again. So if you do elect to do a surety bond and a no contact provision and all of that, I don't want her to have the ability to come up to Miller's Ale House and start this all over again. So That's the only caveat that I'm worried about, is this completely, he has no problem not talking to her anymore. Obviously, that's what started this fight, is I'm not dating you. Stop this nonsense. So we don't have a problem with no contact, but I just don't want her to be, because our position is she's stalking him. So we just want that to be taken into consideration for any bond for this issue.
All right. So on the date of the incident, he was working at the Corner Grill, and now he works at Miller's Ale House.
That is correct, Your Honor. He does not work at Kona Grill anymore.
Okay.
I just want to bring to the court's attention, Your Honor, that there is multiple, plentiful independent witnesses that corroborated what the victim was saying, that saw it happen from beginning to end, Your Honor, and that's what they told the police when investigating.
Well, that, just to segue into that, Judge, what I heard her say was that there was some slapping and shoving going on. I didn't hear anything about the multiple witnesses saying that they said she was working or that he was working. So is that a change? No, put your hand down, Mr. Fox. It's okay. Is that a change in everything, or did I not understand it?
I didn't say anything about anyone working. What I said was the accused came into the restaurant and confronted her and struck her.
Okay.
Okay. All right. I am going to order a $3,000 signature bond through pretrial. I'm going to order a stay away from the Corner Grill as well as Miller's Ale House.
What, Judge? He works at Miller's Ale House.
I'm sorry. I'm sorry. He works at Miller's Ale House. I'll say the Corner Grill. I don't know that I need to, but maybe in the error on caution, I'll just say that there'll be a stay away from the Corner Grill. But with no further contact.
I believe it's Kona, K-O-N-A.
Oh, I'm thinking of a different restaurant.
I know which one.
I should have known, because that's not the address for the Corner Grill. So it's 5100 Avalon Boulevard.
Correct, Judge.
All right, so the defendant is to stay away from that address. There will be no further contact with Jalen Jones. No drugs, alcohol, or weapons while on bond except for those prescribed. And I think that is all. Anything else I need to take up, counsel?
Nothing further.
Nothing further, Your Honor.
All right, thank you. Is that all you have with us, Mr. Barber?
I believe that's all I have. May I be excused, Your Honor?
Yes, you may. Have a good weekend.
Have a good weekend. Thank you.
Position.
Hello?
Y'all froze courtroom too.
Yes.
It's position 8, Frazier.
All right. This is case number 22CR004363Y. Kenny Frazier Jr. You're charged with 2 counts of reckless conduct and a 3rd count of possession of marijuana less than an ounce, all with the offense date of July the 7th, 2022. Pretrial.
This is first arrest. If you give him pretrial, can you set a high bond? Higher than normal.
Okay. Let me hear from Ms. King.
Yes, Your Honor. On yesterday, officers were patrolling the 5 Point Station eastbound platform when the victim in this case, Demetrius Gamble, flagged down the officers saying that there was a gentleman brandishing a gun on the eastbound platform. He stated that he was waiting to go home, waiting for the train to go home, and he noticed the defendant wearing a ski mask, and he pulled out a weapon and was walking behind other people. The officers asked him if he wanted to complete a statement at that time, and he said no. But at that time, the officers approached the defendant and began to speak with him, the person that matched the description that the victim gave. And they noted not seeing a weapon at that time. But while they were talking to him, the defendant started to argue with the victim. And while they were arguing, the defendant actually pulled up his shirt, showing the gun to the victim again, and as well as the officers. At that point, he was detained. They noted that the gun was loaded with rounds and one in the chamber. The safety was not secured at that time, Your Honor, as well. For that reason, the state is requesting a $10,000 surety. That will be $4,500 for each reckless conduct and $1,000 for the marijuana possession. A stay away from the 5 Points MARTA station located at 30 Alabama Street Southwest. No further contact with Demetrius Gamble, Demetrius, last name traditional spelling, and no drugs, alcohol, or weapons while out on bond.
All right, Ms. McLeod?
Yes, Your Honor. My client is 24 years old. As Fitzgerald has noted, he has never been arrested. He is a native of Atlanta, gainfully employed. He has no children. He tells me that has a permit for his weapon, and he did not brandish it at all. He totally denies that he brandished it. He doesn't know who the complainant was. He was not threatening in any way. Georgia is an open carry state. My client had a right to have a gun on him, and he was not being reckless at all with this gun, Your Honor. I think that someone saw a gun and did not like the fact that they saw a gun. But the fact is that Georgia is an open carry state. So someone can carry a gun. He did not brandish it at all, Your Honor. I think he's a good candidate for a signature bond because he has no record whatsoever of any kind of crime, and he was not threatening the alleged victim. Thank you, Your Honor.
All right.
Your Honor, there were 3 officers present when he lifted his shirt and showed the gun. That's what the officers saw, Your Honor.
But showing a gun is not threatening someone.
He was showing the gun in the middle of a heated altercation. The officers even noted that they had to break them apart because the argument got so heated when he showed the gun. So it wasn't for museum purposes. It was to intimidate the victim.
He did not know the victim at all. They had no altercation. I guess when the police came, and he may have said something because he didn't know what it was all about, but he did not have a previous altercation with the victim before the victim called the police. This is the difference.
Okay. All right, I am ready to rule. And what I'm going to do is I'm going to grant a $10,000 signature bond through pretrial. And that will be $4,500 on each of the reckless conduct cases, and then $1,000 on the possession of marijuana. And I'm going to order that there obviously be no drugs, alcohol, or weapons. Did they surrender? Do they have the weapon, or do we know? Do they
Yes,
know?
Your Honor, they support the firearm.
They have, okay. All right, but no other weapons. If he has any other weapons, Mr. Frazier, he needs to leave them at home and certainly not carry them around while he's on bond. So he's to have no weapons on him at all while on bond. I'm going to order stay away from the 5 Points MARTA station at 30 Alabama Street. And I think that will be all that I need to take up at this time. Anything else from council?
No, Your Honor.
Nothing further.
All right.
All right.
Position 13, Lindsay. I didn't say. Lindsay.
This is case number 22 CR 004365A. Andrew Lindsay, charged with 1 count of DUI, less safe, a 2nd count of driving defective or no headlights. Offense date is July the 8th, 2022. Pretrial. You're on mute.
My bad. First arrest, resident of Union, New Jersey.
All right. Miss Duncan. Okay, Miss Duncan.
This is my case, Your Honor. This incident occurred yesterday in the area of Kimball Bridge Road in Johns Creek. Yesterday at around midnight, officers observed a black 2022 Jeep Compass being driven on Kimball Bridge Road without lights on at all. Because there were no lights on this vehicle being driven on the main road, officers initiated a traffic stop. And upon initiating the traffic stop, they spoke with the defendant in this case about the violation. And while speaking with this defendant, they observed the odor of alcoholic beverage coming from inside the vehicle. The defendant agreed to do sobriety tests, and during the test, the accused showed many cues of impairment. He struggled to remember simple tasks and exhibited a drunken demeanor. Officers also noted that the defendant in this case had bloodshot, watery eyes, and there was an odor of alcoholic beverage coming directly from his breath when speaking with him. Your Honor, driving while under the influence alone is very, very dangerous to the particular defendant and to the community at large, as well as other drivers on the road. So the state has a very large concern here about the dangerous behavior taken while driving a moving vehicle, especially given that it was midnight, dark outside, and this defendant was driving with no lights on at all. Additionally, the state does have concerns that this defendant's ties to the community may be insufficient. Additionally, the defendant has no recent criminal history, but does appear to have 2 speeding tickets from 2008 and 2009. Given the reckless and dangerous nature of the offenses alleged, Your Honor, as well as this defendant's ties to the community and the concerns that we have regarding that, we're going to request a total $3,000 split bond. That's $2,500 for the surety for the DUI and a $500 signature bond for the no headlights charge. No alcohol, drugs, or weapons, no further violations of Georgia law, and a defensive driving course. Nothing further from the state.
All right.
Yes, Your
Ms.
Honor.
Kim?
Yes, Mr. Lindsay is actually 43 years old. He resides in New Jersey, and he was here in Atlanta, Georgia for a business trip. Indeed, he was supposed to fly out today, United Airlines by 6:55 p.m. He does not have ties to this community. However, he's a very responsible businessman. He will come back for the court. He will take care of this matter. He has no prior history of any kind of failure to appear. This is his first arrest, and we would like to request for signature on bond as pre-trial services also recommended. So, thank you.
And what
That
did
was
you tell
jail,
me?
not pre-trial.
Yes, jail. Gotcha. What did you tell me he does as far as the reason he was in town? I couldn't hear
Business
you.
trip. They have a company has meetings with American Airlines. They have a networking meetings for the company employees to discuss the business reasons.
So he was here for a meeting with his job.
Correct.
Okay.
Your Honor, and while on that meeting for his job, he decided to get what the officer described as inebriated and drive without headlights on after midnight. So the state will request that the court grant our bond recommendation. Nothing further from the state.
All right.
Your Honor, he was actually driving a rental car. He didn't know that headlight was broken.
All right, I'm going to go with the state's recommendation, do a split bond for $3,000, $2,500 surety bond on the DUI, and a $500 signature bond on the driving with no headlights. And that $500 signature bond will be through the jail. There will be no drugs, alcohol, or weapons while on bond. And I believe that will be all that I need to take up at this time. Is that correct?
Yes, Your Honor.
Would the court consider imposing a defensive driving course?
Your Honor, he's not guilty for this charge. There's no need for a defensive driving course.
I usually don't do it at this time. It's probably not going to do any good at the moment. And hopefully, if his license has been suspended in New Jersey, I don't know. He will find out before he starts driving, or else he shouldn't be driving unless he has a valid driver's license, I guess, in New Jersey, where I'm assuming his license are out of. So he needs to check that upon making bond to find out if you still have a valid driver's license.
Thank you, Your Honor.
Condition 9, Mr.
Your
Gore.
Honor.
Judge, what was the other condition? You said no driving without a valid?
Valid license, I guess, from New Jersey or wherever.
Oh.
I'm not gonna limit it to a certain state because I don't know. Right,
Okay.
what state he may have a license in.
Okay.
All right, who do we have, deputy? I'm sorry.
Gore, I think she said number 9, right?
Condition 9, Gore.
Okay, thank you. It's 22 CR 004364A. Gregory Gore, you're charged with 1 count of battery family violence. Offense date is July the 7th, 2022. Pre-trial.
13 total. Last arrest was 2015. Suspended registration, suspended license. Pled no load. Before that was 07 marijuana possession, no load. He has 2 holds. Probation hold out of Forest Park and a failure to appear out of Canton, Georgia. What's that, Cherokee County? I think.
Yes.
Something like that. That's it.
Okay. Ms. King?
Yes, Your Honor. On yesterday, officers responded to a fight call at 2210 Wingate Street. Upon arrival, they spoke with the victim of this case, Ms. Latanya Gore, Latonia. Gore, last name is a defendant. She advised that her husband locked her out of the house and she was attempting to get back in to get her items. Eventually, she was able to get in, and while she was removing her items, the defendant struck her with his fist. The officers noted swelling in her face and a busted upper lip. The warrant states that they live together at this location. We have spoken with the victim who states that is not their, that's not where they reside together. So as far as the conditions, I will defer to the court, but the state is requesting a $4,000 surety, no further contact with Latanya Gore, and no drugs, alcohol, or weapons while out on bond. Also, to be clear, Your Honor, the state is requesting a stay away from that incident location because at this time, the officer did provide that they did live together at that address. But if it's incorrect, I will defer to.
Okay, I see that we have our victim on the line, Ms. Gore. And Ms. Kim, do you want her, if she wants to speak, to go before you, or do you want to present first?
May I please present first?
Okay, and Ms. Gore, are you on the line with us?
Yes,
Would you like to address the court?
yes, I'm not.
Hold on. You have to answer the question first, yes or no. Do you want to address the court?
Yes,
Okay, so hold on, Ms. Kim wants to go first, and
Sure.
then we'll allow you to
Turn her
address.
camera, Judge.
Yes.
Yes, and you have to turn on your camera, Ms. Gore, when you're ready. There you go, to address the court. Hold on, mute yourself for a second, and I'm going to let Ms. Kim go before you, okay? All right, thank you. Ms. Kim?
Yes. Mr. Gore is 49 years old, and they have been married more than 35 years. This incident happened yesterday, and he has no time, he has no flight risk. Of course, there are 2 holds, so he cannot go any other place other than either Clayton County or Cherokee County after he takes care of this matter here in Fulton County. He has been here in Georgia for 49 years, and he's married, of course, and his families are all here. And he has not had a job for last 1 week. He was cutting grasses for last 2 years, and his high school education is up to 9th grade. So he does not have much of income to pay for high bond. So we would like to request for low bond if he cannot get a signature on bond. We prefer him to get a signature on bond so that way he can go and take care of other warrants at Clayton County and Cherokee County, Your Honor. Thank you.
All right. Ms. Gore, can you unmute yourself for me? Can you raise your right hand for me?
I can hear you.
I'm sorry?
No, I said I can hear you now.
Okay, raise your right hand. Do you swear or affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
I do.
All right, what would you like to tell me briefly about this incident?
The incident was my fault.
Okay, are you in fear of Mr. Gore? Are you in fear of Mr. Gore?
No,
And there was some discussion, do you all reside or did you at the time reside at this 2210 Wingate Street?
I was living with him because I'm homeless, but I have a room now, so I'm okay.
Okay, so you do not reside there at the 2210 Wingate Street?
No,
Okay. All right. Anything else?
no, I just wanted to say that the incident was my fault, that he shouldn't have battery, a charge of battery, because it was me.
Okay. All right, anything else? Any cross-examination from Ms. King or Ms. Kim?
Ms. Gore, were you the one that called the police?
Excuse me?
Yes, Ms. Gore, can you hear me? I'm sorry.
I can hear you now.
Yes, were you the one that called police?
No,
Who was the one that called the police?
my neighbor.
Okay. Is this a neighbor you're familiar with?
Yes, ma'am.
Okay, thank you.
We would like to request for a signature on bond since my client is not a first aggressor, nor he is not in fault.
Your Honor, you're well aware of the cycles of violence, Your Honor. I know you know that, Your Honor.
Yes. All right, I'm ready to rule. I'm going to order a $4,000 surety bond. I'm going to, I won't worry about the stay away, but no further contact with LaTanya Gore. So Mr. Gore can't have any further contact with your wife while you're on bond. And obviously, if you can't have any contact, you can't be living together. So hopefully that will not be happening. No drugs, alcohol, or weapons while on bond. And I guess that's all I need to take up. Is that it, Counsel?
Yes, Your Honor.
Okay.
Nothing from the state, Your Honor.
Okay. All right. That will conclude $4,000 surety bond.
Position 11, Ingram. Sorry, position 11, Ingram.
Okay. All right, this is 22 CR 004370H. Terrence Ingram, you're charged with 1 count of simple battery family violence. The offense date is January the 21st, 2022. Pretrial.
7 total. Last arrest was on the 3rd of this month. Criminal damage to property, 2nd degree. That's open in Cobb. 2018 probation violation out of the cab. 2015 probation trespass. 2015 entering auto conviction. 2014 failure to appear for criminal attempt. That was dismissed. He got a trespass conviction from 2012. And he has an FTA warrant out of Brookhaven. That's it. Yeah.
Your Honor, this incident occurred on January 21st, 2022 at 9:15 Tussle Tree Court, Southeast, apartment 800, that's TEESLETREE Court. In this incident, Your Honor, the victim is Shaquita Carr, SHAQUITA. Carr is CARR. In this incident, Your Honor, Ms. Carr is the mother of the same child as the defendant in this case. And this altercation occurred when she asked him about violence that her child mentioned witnessing while they were in their father's care. Ms. Carr stated to officers that she was trying to see what her child was talking about. And an altercation ensued verbally, and the defendant got upset and was attempting to take her child without her permission, so she jumped into the car to stop him. The warrant indicates that he grabbed her by the neck and pulled her out of the car. Ms. Carr stated to our victim advocate that while he was grabbing her by the neck, she briefly could not breathe and that she did have minor bruising as a result of the contact. She also stated to our victim advocate that they are not in a relationship and they don't live together. And in fact, that incident location is her location. And then she said that she does not fear this defendant. However, Your Honor, we are concerned due to the nature of the physical violence. She did note that she was grabbed by the neck and so hard that it did cause bruising and she could not breathe for a momentary second. But Your Honor, that's very, very dangerous to anyone's health. Here we have a concern about intimidation of the witness because they do share a child. And then we also have a concern about flight risk. Your Honor, as pretrial has mentioned, this defendant does have previous FTAs as well as outstanding warrants in other counties. For these reasons, Your Honor, as far as intimidation and also including the risk of reoffending, given that this incident did occur at her home, we're going to request a $3,500 surety. No further contact with the victim in this case. Third-party child contact, a stay away from her location, 1-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law. Nothing further from the state.
All right. Ms. Kim?
Yes, Your Honor. Mr. Ingram is 28 years old, and he has been here in Georgia for all his life. Not only his child, he has his parents, his sister here in Georgia. He's also gainfully employed at True Green Lawn Care Service as a lawn technician from February 2022. So he does have a strong ties to the community, and we would like to request that signature on bond. However, if Your Honor is not inclined to give him a signature on bond, we would like to request for maximum $1,000 surety bond. And this incident happened January 21, 2022. So no further violence context should be enough. However, my client does not object to stay away or no further contact. And that's about it, Your Honor. We would like to request for a very low surety bond, maximum 1,000. Thank you.
All right, I'm going to order a $2,500 surety bond. I'm going to order stay away from the incident location. I'm going to order no further contact with Shaquita Carr and no drugs, alcohol, or weapons while on bond.
Your Honor, would the court order the third-party child transfer?
Yes, and a third party person for transfer, there's visitation allowed with the minor child.
Thank you.
Thank you. Nothing
Excuse
further.
me, Judge, what's the address? Or anybody can give me
915.
I have 915 Tefel Tree Court,
Yes.
Southeast Apartment 800.
Okay, I didn't hear it, I'm just sorry. Didn't hear it. Also, Judge, we have a private attorney online for position number 12, and he's, can we deal with him next, if he's next in the courtroom?
Okay. Deputy in courtroom 2,
Yes.
we have an attorney on the line. Is that who we have? Position 12?
That's correct, James.
Mr. James, is it James?
Come on, Mr. James. No, no, no.
Good afternoon, Judge.
Good afternoon.
Good to see you.
You too. All right, this is 22 CR 004369F. Mr. Carl James, the charge is driving, striking unattended vehicle. The offense date is April the 3rd, 2021. Pretrial,
I got his first arrest. SOB jail, the recommendation though.
okay.
Your Honor, in this case, it occurred at the area of Carroll Street and Pickett Street, according to the warrant. In this incident, Your Honor, it is alleged that the defendant in this case was driving a 1964 Chevrolet Greenbrier van. The vanity.
Hold on a second, I'm getting a lot of feedback. I'm not for sure from where. State again, you started with defendant was driving.
Okay, defendant was driving a 1964 Chevrolet Greenbrier van with a Georgia vanity tag of B free, the letter B FREE. That vehicle was said to have struck a 2013 Mercedes-Benz KS bearing the Georgia tag C6301119. It was unattended, and at that time, this defendant did fail to immediately stop and either locate and notify the operator or owner of the vehicle. Additionally, it is noted in the warrant that the defendant did state that he was going to turn around and exchange information, but instead he left the area and did not return. There were several witnesses who recognized him as a local artist. These witnesses provided the name of the local artist that they knew and that they recognized, and officers indicated that the name that they recognized corresponded with the registration of the vehicle that hit the unattended Mercedes-Benz. And for those reasons, Your Honor, given the fact that there was a very unique tag and this driver was identified as the one who hit the vehicle, even though he has a limited history, pretrial said first offense. However, I did see a speeding ticket from 2013. However, the state is going to request a $500 signature bond, a defensive driving course, no alcohol, drugs, and weapons, and no further violations of Georgia law. Nothing further from the state.
All right, Mr. Axon. You're on mute.
Yes, thank you. I have to confess and apologize to the court that you have to deal with this case. I do have to give you some of the factual background. As an officer of the court, I will state in my place, I have retrieved the body cam footage, which I've reviewed the officer that appeared at the alleged hit and run. I have collected the police report and I've reviewed the warrant. The problem is, even on the face of the warrant, it says he failed to immediately stop, failed to locate the owner, failed to notify the owner. And then when you look at probable cause, it talks about things that he said to the owner of the vehicle. They leave out that the probable cause comes directly from the owner of the vehicle. Even in the police report, it says he stopped, they had a conversation. I won't go into the details because there is a factual dispute as to the alleged victim. The complainant says that Mr. James did not give him his information. Well, Mr. James offered to give him his information and the owner said, no, it's okay. And I believe, I'm just going to put it out there, Judge, I believe he did that because the owner of the vehicle that was struck was parked illegally in a no parking spot. And I have to point out also that this happened in Cabbagetown. Anybody that's familiar with Cabbagetown knows only one car can go down the street at one time, even though it's a two-way street. Another car is approaching Mr. James. He tries to pull out of the way. He does not strike the vehicle. The front of his van catches the front bumper of a Mercedes S-Class vehicle that's parked illegally where it should not be. It catches the bumper. Mr. James pulls over with his wife and 2 kids in the car, has a 10-minute conversation with the owner, waits for the owner, looks for him. He comes out of a restaurant. They have a 10-minute conversation. The owner tells him to go on about his business. Mr. James leaves. 2 months later, that was in April, Judge. 2 months later, really the next month, he gets a notice from his insurance agency that there's a claim filed. Mr. James cooperates, says it was his fault. I've looked at the payment history, Judge. The insurance paid $15,000 to have the car fixed. Mr. James' insurance also paid for the driver of the vehicle to have a rental car during that time. I have to point out.
Object, Your Honor. The state will contend that this is currently not trial and we're here for the purposes of bond only. And for those reasons, the state would just like to object to this. We do not have this information that defense is currently speaking of, and I understand that that may be available soon, but based on the information that we received, we do have a warrant and we do have probable cause for the charges. And furthermore, the state is requesting a signature bond through the court in the amount of $500. And by defense's own admission, the defendant did catch the bumper of the alleged Mercedes-Benz. If the court would like for defense to continue, the state would not be opposed. However, we just wanted to make it known for the court that this is not trial and factual issues are issues for trial. Right now, we're here for bond.
All right, I tend to agree, Mr. Axum. I don't generally get too deep into the factual basis at this point. The state has agreed to a signature bond, and I'm inclined to do the same. I don't know if you want to.
No, I'll get to the point, Judge, but they gave a very flawed factual background. I don't think it should be a $500 signature bond. I actually think the warrant should be dismissed based on the flaws in the face of the warrant.
Okay.
Let me just say, Mr. James lives in Atlanta. He owns an art gallery. You've heard his criminal history. He's got 2 kids, a wife. He's lived in the same house for 12 years. The piece that I need to address to the court, the piece that really infuriates me as an officer of the court is no warrant issued, Judge. The officer did not issue a warrant. The warrant came the January of this year. So after the vehicle was paid for and the case is settled, a civil complaint was filed for $250,000 for a parked vehicle against Mr. James. Hang on. I understand there's an objection, but I need the court to understand how the warrant was signed and why it was signed. In January of this year, that warrant was signed after the complainant continued to call the police department after he filed his civil complaint. So the court is being used. I just want to make the court aware of that. So Mr. James has lived here for 14 years. He's got 2 kids. He owns a business in underground Atlanta, an art gallery. I would ask for a straight signature bond. That's it. That's my case, Judge, and I appreciate you indulging my time.
All right, thank you. All right, I am not going to dismiss the warrant at this point, but what I will do is grant the signature bond, and I'm going to grant the signature bond through the jail, and the amount will be $500. I will order no drugs, alcohol, or weapons while on bond. And I think that's all. There's nothing else that I need to take up. But I will grant the $500 signature bond at this point, Mr. Axum.
Thank you, Your Honor.
All right, thank you.
All right, take care. Okay, what do we have next?
Position 10, husband.
This is 22 CR 004368J. Salvador husband, you're charged with one count of willful obstruction of a law enforcement officer. Offense date is February the 3rd, 2022. Pretrial.
This is fourth cycle. He got open cases in Judge Dunaway. State, you want to read them off, or you want me to go to Odyssey and pull them?
I would, Your Honor, and I would respectfully have to disagree with pretrial's recitation of this defendant's criminal history. The GCIC in this case and the case manager that is available to the Fulton County Solicitor's Office are inconsistent. Upon putting in the biographical information for this defendant, in addition to what is listed as the 4 offenses on the GCIC, which are the 4 open cases, in Fulton County alone, this defendant has at least 37 charges. Of those charges, from 2016, there is a NOLO suspended or revoked license charge, suspended or revoked license and child restraint not used. Charge from 2017 and 2018, fleeing or attempting to elude and driving on the wrong side of the road. A 2020 simple battery, family violence, and criminal trespass conviction. In addition, there are other arrests for a charge that I will not sound. There are at least 3 counts of FTA arrest in 2018 out of Fulton County. There is a carrying a concealed weapon and possession of marijuana less than 1 ounce that was transferred to state court from felony. It has no disposition. And in addition to what I just stated, there are 4 open cases for this defendant. 22 CR 003648Y. It is a fare evasion and an obstruction charge. There is 21 SC 177380, which is ag assault, interference with government property, 2 counts, obstruction, theft by receiving stolen property, cruelty to children in the 3rd. There is 21 SC 177782, home invasion in the 1st degree, armed robbery, 2 counts, aggravated assault with a deadly weapon, 2 counts, aggravated assault, 2 counts, terroristic threats, possession of a firearm during the commission of a felony, and the case manager states that there were too many other charges to display at that time. Further, there's another open case, 22 CR 003802J, which is a willful obstruction charge from February of this year, Your Honor. And this incident, it did occur on an additional one from February of this year. This incident did occur on February 3rd. Investigator Brown initiated a traffic stop on a silver Ford Explorer near the intersection of Browntown Road and Hollywood Road Northwest. And the vehicle failed to yield to the emergency vehicle that the officer was pursuing in by continuing on Hollywood Road. It proceeded through the red light on Hollywood Road and Perry Road. The vehicle proceeded to drive on the wrong side of the road, approaching Peyton Drive, and due to traffic being stopped at the red light, the vehicle ran the light while making a left turn. After running the red light, it made a left turn onto James Jackson Parkway and Peyton Road. The vehicle lost control and crashed into some trees off the side of the road. The warrant indicates that there were 3 Black occupants that exited the vehicle. The registered owner of the vehicle was apprehended on the scene of the crash. The other 2 occupants fled through the woods. The driver of the vehicle was also apprehended at the other end of the wood line near the intersection of James Jackson Parkway and Bolton Road. And the other passenger, identified as the defendant in this case, was not apprehended at the time. However, he was identified because his identification was left in the car. And that's how officers were able to make an identification in this case. Here we have a concern about the risk of reoffense. As I've stated to the court, this defendant has at least 4 open.
I will. Okay.
The defendant has at least 4 open willful obstruction charges with Fulton County. So we're going to request, there is $8,000 preset bond. So the state is going to request that that $1,000 preset bond be increased to a 2,500 surety bond. There be no alcohol, drugs, and weapons, and no further violations of Georgia law based on the risk of reoffense in this case. Nothing further from the state.
Hold on, Judge. State, how many arrest cycles do you have? Because I have 4.
I have 37.
I don't know.
At
That,
least.
that can't be him. He only 20 years old, so he don't have 37 arrest cycles, I'm sure. Is some of it juvenile or something?
No.
No, that's I don't think that's him.
You know, I'm a junior. I have my dad last
Yeah.
night.
Nah. His history starts with 2019.
Okay. Well,
Now he does have all of those charges that you listed that's in Judge Dunaway, the home invasion and all that. That was under his on the Odyssey, but that total arrest is not. That's incorrect.
And the charges I've listed are from 2016 to 2020 as far as convictions. However, if there is a discrepancy in the record, the defendant may take that up with his attorney. However, that is what the state has located. But as pretrial has confirmed, there are at least 4 open cases. And in those 4 open cases, there are at least 4 open obstruction charges, as well as other open violent felony charges. Given the facts, again, Your Honor, and the circumstances in this case, we're going to ask for that $1,000 surety to be increased to 2,500, no alcohol, drugs, and weapons, and no further violations of Georgia law. Nothing further from the state.
All right. Who's there for? Is it Ms. Kim's case?
No, this is actually Miss Attorney McLeod.
Oh, I'm sorry, McLeod.
Yes.
Okay, go ahead.
Your Honor, my client is 20 years old. He tells me that he is gainfully employed and that he has only been arrested once. He says that he did not know anything about this incident at all. It was something that may have happened a long time ago. He denies that that the allegations made by the prosecution are accurate. He's given the fact that he's only 20 years old, Your Honor, I would ask the court to consider giving him a signature bond so he can get out of jail and get on with his job.
Where does he work?
He's a driver, Your Honor.
Oh, a driver?
Yes, Your Honor.
What, for Uber or Lyft, that kind of thing?
Oh, no, for rent-a-car company.
Oh, rental car company. Okay.
Just keeping in mind, he does have 4 other open obstructions.
That is concerning to me with the 4 open cases. And tell me again the state's recommendation.
The state's recommendation is to increase the $1,000 preset bond to a 2,500 surety bond, no alcohol, drugs, and weapons, and no further violations of Georgia law.
Your Honor, my understanding is that he doesn't have any convictions, or did I mishear what was said?
Yeah, they didn't say any convictions, just the 4 open cases.
That is correct. So he is presumed innocent.
If I may clarify for the record, pretrial indicates that there are no convictions. However, there is discrepancy as to whether or not the convictions located on the record belong to the defendant or his father. And that's something that he'll have to take up with his attorney. The state's position is that their criminal history is inconsistent and there are convictions. However, based on the contention that has been made public to the court, the state is going to rest on the fact that there are open cases with obstruction charges in those.
Your Honor, very often when people have the same name, their histories are confused and mixed up, and it has happened. My client is only 20 years old, so there is a good possibility that these may well be his father's cases and not his.
That's concerning as well.
Yes, Your Honor, but he can't be held liable for what his father does.
No, I understand. I'm going to order a $3,000 signature bond through the jail. And I'm going to order no drugs, alcohol, or weapons while on bond. And I think that's all I would need to take up at this point. Is there a no further contact request?
No, Your Honor. He is accused to have ran from a vehicle that crashed into a tree. So there is nobody to contact other than the tree in this case. So
other than the tree. I was making sure you weren't going to say the officer.
No, Your Honor.
Okay. All right. Stay away from the trees. Okay. All right. $3,000 signature.
Is it through the jail or pretrial, Judge?
Through the jail.
Okay, thank you.
All right. Thank
Next,
you.
we have position
Thank
15,
you, Your Honor.
Mr. White.
All right. This is position 15, 22 CR 004366F. Tyon White, you're charged with terroristic threats. And that offense date is July the 2nd, 2022.
You waiting on me?
Yes, sir. Pre-trial. You said 8?
Yes, 8. He got history out of Florida and Georgia. He got a 2012 sale of marijuana, possession of a Schedule II controlled substance. They were indicted and dismissed. He got a reckless conduct misdemeanor possession of marijuana, NOLO, from 2009. Last arrest in Florida was 05 battery DV. It was dismissed. He got marijuana possession from 02 and a battery from 2000 dismissed. I'm gonna defer to you on this one.
Okay.
And this
All
is
right, Ms. Duncan.
This is position 15, White, correct?
Yes, ma'am. Correct.
Your Honor, this incident occurred on July 2nd, 2022. The incident location is 160 Turquoise Trail in College Park. The victim in this case is Nevaeh Russell, Nivea. We have Russell as Russell. In this incident, officers were dispatched to this location in reference to a domestic dispute. The location is actually a boarding house, Your Honor. And what officers were informed of once they arrived was that there was a verbal altercation between the defendant in this case and Ms. Russell, where during that verbal altercation, the defendant in this case pulled out his firearm and put it on his lap and told Ms. Russell that she better get out of here before he had someone come and shoot up the house. There was a Mr. Davion Hambrick who witnessed the threat that was made to Ms. Russell and witnessed the defendant in this case pull out his firearm. The firearm was later identified as a silver revolver. In this case, our victim advocate did get a chance to speak with the victim, and she did state that this is a boarding house where they both live. She stated that there have been incidents between her and this defendant prior to this date. She said that she does fear this defendant and would like no contact and for him to stay away. Here we have a concern about the risk of reoffense, given that this is, they both live there, Your Honor. So, and out of caution for our victim's safety, we're going to request that the state's recommendation, my apology, is a $2,000 surety, a no further contact with the victim in this case, a stay away from the incident location, 1-day anger awareness, and no alcohol, drugs, and weapons, and no further violations of Georgia law.
All right, Ms. Kim.
Yes, Mr. White is 45 years old, and he has been here in Georgia for about 5 to 6 years. he actually is moving out from that location, the boarding house. So he does not object to stay away from that location. And he does not object to no further contact either. He has four children, and he's engaged to a fiancée, and he has been working at Georgia Tech as a maintenance about 2 years. He has 2 years of college for business management as well. He just needs one time escorted visit to retrieve his personal belongings from 160 Turquoise Trail. And he denies the allegations. That's not the way it happened. He also has some medical condition that he needs medicines and he has to take care of. We would like to request for a signature on bond, as his last arrest was more than about 10 years ago, and it has nothing to do with the violence. And so he's qualified for signature on bond. Thank you, Your Honor.
All right.
Your Honor, the victim in this case does appear to be on the line. I don't know if she is willing to speak, but just as an aside, Your Honor, given the fact that it is alleged and witnessed by others that this defendant felt the need to pull out a firearm when arguing with a woman, we have serious concerns about this defendant's behavior, and we're asked that the state's request be granted. And I see that Ms. Russell has turned on her camera. If Your Honor would like to sound for her.
All right. Ms. Russell, would you like to address the court?
Yes, Your Honor.
Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, Your Honor.
All right. What would you like to tell me about this incident?
It happened multiple times. It's not the first time it happened. It's just the first time that a firearm was, involved in this situation. And, it escalated from there.
All right. Are you in fear of Mr. White?
Yes.
And do you all reside together at the Turquoise Trail?
Yes, ma'am. The police were just out here today, and it was like the roommates, everybody's starting to fear for their life in the house.
Okay, so it's a rooming house, I understand, correct?
Yes, ma'am.
Okay. Are you in a relationship with Mr. White or no?
No.
I'm sorry?
No, ma'am.
No, okay. All right, I'm gonna go ahead. Is there anything else from counsel, or do you all want to cross-examine this witness?
No, Your Honor.
Nothing further from the state.
Nothing further from defense as well.
Okay, I'm going to order a $2,000 surety bond. I'm going to order that there be a stay away from 160 Turquoise Trail for Mr. White. Gonna need to find somewhere else to stay. No further contact with the victim.
Quick, please.
Navia Russell.
Your Honor, can I speak real quick, please?
No, please.
I doubt it. I doubt your attorney's going to allow you to do that. I have to make sure that my victim will be protected, Mr. White. So while you're on bond, you need to find somewhere else to stay.
I was already on my way out, Your Honor, anyway, and it wasn't nothing going on like that anyway. I was just already ready to move anyway.
Doesn't matter, Mr. White. I think you need to hold your conversation and hold your statements. Be careful, because they can and will be used against you. But it'll be a $2,000 surety bond. I'm going to allow a one-time escort with law enforcement. If Mr. White gets out on bond and needs to go back to that location, that he must, and Mr. White, if you do get out and go back, you must have a police escort to go back there, or else you'll be arrested in order to retrieve any personal belongings that you may have. So anyway, stay away from that location. Unless you go back one time with the police. No further contact with Navia Russell. No drugs, alcohol, or weapons while on bond. All right, that will conclude this matter.
Judge, are you including the other victim's name also that they mentioned?
Oh, there was 2 victims? Did I
There was,
miss?
One.
there was one victim and a witness, Davion Hambrick.
Okay, I think he was a witness, not a victim.
Yes.
Okay,
Right, there was a witness.
okay.
Yeah.
I just want to make sure. And also, position number 1, there is a private attorney on record, even though I know that the PD filed a waiver of his appearance. But he
Judge,
just
I'm
indicated.
sorry, excuse me. I wanted to make the quick announcement that way we can be excused.
I'm sorry.
Hold on, there's another attorney on the line for position 1. I need to get a clarification who's representing him. Because the public defender's office filed a waiver of his appearance, and if the attorney can turn on his camera, oh, he did. Mr. JT Salton. I guess he could speak for himself.
Yes, Mr.
Good
Salata.
morning.
I'm
Good
sorry, I
afternoon,
did
Your
not
Honor.
notice you were there. I would not have made you wait this long if I could help it. Sometimes I'm not in control. I have to do what the deputies at the jail tell me.
It's no problem, Your Honor. Thank you very much. It's been a very good learning experience for me, so it was not a waste of time. I
Okay,
would like to be heard. The Honorable Ms. Gant entered a waiver of my client's presence at first appearance. I'm honoring that waiver, of course.
Okay.
It's my understanding he is in the infirmary
Excuse me, I'm sorry. I don't
and
mean-
he's very sick. Go ahead.
okay. All right, deputy in courtroom 2. Yes,
I'm
ma'am.
so sorry. I don't mean to interrupt. I just wanted to give a quick announcement so that we can be excused
Okay.
because we're completed here.
Oh, okay.
What the attorney was saying, position 1 did waive his appearance. And that's his case, the private attorney's case, and also position 6 waived their appearance, and position 2 bonded out.
And I'm sorry to interrupt. Did position 14 also bond out? Is my
Yes.
understanding?
Yes, yes.
Yes, that is correct.
Okay, thank you.
All right, thank you. So you're gonna turn off your camera so you can go do some other things, deputy. I understand.
Thank you, Judge. Have a
All
good
right,
day.
see you next time. You too.
All right, bye-bye.
Bye-bye. All right.
Your
so we're-
Honor,
Yes.
this is ASG back. Is as to, for position 1, can we have the attorney file the waiver for the client?
Yes, now if the attorney is also going to represent him going forward, Mr. Salata, if you could, is it Salata?
Yes, Your Honor. Thank you.
Okay, if Mr. Salata, if you could file the waiver and the entry, have you filed an entry yet either?
I have sent that to Miss Lewis,
Uh-huh,
Your Honor, and excuse me if I'm looking away, I'm making sure it went.
okay,
I emailed that to Miss Lewis. So she should have it, and I'll be happy to do a waiver. If the court wants to wait for me, or I can do one right after we finish.
we can do it right after. Miss Lewis, do you have the entry?
It's coming. It hasn't hit my email yet.
Okay, all right, yeah, you can do it after. We won't hold everyone up for that. We trust you'll get it back to me.
I got it now.
Okay, as we speak. Yes, but afterwards, if you could forward that waiver as well to Ms. Lewis, and that'll be fine. I'm going to go ahead and call this case 22 CR 004367C, Brian Matthew, and I think it's Archipley.
Yes, Your
Archipley. All right. I've got 1 count of DUI, less safe, and a 2nd count of driving failure to signal lane change or turn, both with the offense date of July 7th, 2022. You have anything pre-trial?
This is 3rd arrest. Last arrest was June 27th of this year for trespass. And he has a Michigan arrest. Let's see, from 1998, dangerous drug. So he just had an open case, 22 CR 004 126 C as in cat in state court. That's it.
All right. Ms. King?
That would actually be my case, Your Honor, ASG
I'm
back.
sorry, Ms. Backus.
Oh, no, it's okay.
Okay.
It's okay. So Your Honor, we don't have all the facts in this case. We have requested the police report and the supporting evidence, and we're still waiting for that. But according to the warrant, the citation, this incident occurred on yesterday, July 7th. A Johns Creek officer made a traffic stop because he observed a vehicle making several erratic turns fairly abruptly and with no signal. At one point, the driver even crossed over the gore. And so the officer stopped him. Upon the stop, the officer, who is trained in field sobriety observation and testing, he basically said that the defendant's or the driver's mannerisms were consistent with someone under the influence of a stimulant drug. And he showed signs of impairment during the standard field sobriety test. And there was a blood test conducted under the implied consent notice. So as Your Honor can guess, the driver is the defendant. But we, like I said, Your Honor, our biggest concern with this person or with this defendant is that he's got that criminal trespass from, I believe it's June 27, 2022, 2 counts of criminal trespass, 22 CR 00412-6C. He had a $2,000 signature bond on that. He obviously did not abide by the court's ruling to not get into any more trouble while he was out on bond, because this case happened just a month later. So based on the nature of the offense, we know that DUIs are very dangerous, not only to the individual, but to the other people on the road. And so we are asking for a $5,000 surety bond, $4,000 for the DUI and $1,000 for the other charge, no driving unless to designated locations, and alcohol, 1-day alcohol assessment or awareness, and no alcohol, drugs, or weapons while out on bond. Nothing further, Your Honor.
And what was the 1-day?
1-day alcohol. What?
So I'm sorry. It's hold on one second. What course were they trying to? There was a course. Hold on one second.
There's no alcohol in the case. No,
this is true. This is true. They did say that it was a stimulant drug, but he obviously was driving under the influence. And so
I don't know about obviously. There's no indication.
I will tell you, based on somebody who has experience, based on an officer who has experience in field sobriety observation and testing, based on what they observed, based on a blood test and based on a field sobriety test, they made the determination that the defendant was driving under the influence of something. And so, Your Honor, I will get back to you on what that was. It may not have been alcohol. I may have wrote it that way. Let me check my notes. You can nothing further at this time.
All right. Go ahead, Attorney Salata.
Thank you, Your Honor. First of all, I have the honor and privilege of representing Brian Archibald. He is 49 years of age. 2 weeks ago, he was arrested, charged with criminal trespass. He did enter to a signature bond, $2,000 signature bond. He signed himself out, and so he was out on bond at the time he was arrested. I have a copy of the warrant. The first warrant is for an arrest under OCGA 40-6-123, turning movements and requires signals. And Your Honor, I would move to dismiss that warrant. First of all, under 40-6-123 and under the facts as stated by this officer in this warrant, there's been no crime committed. You do not have to use a turn signal when changing lanes on a multi-lane highway going the same direction. The law does not require that. Under 40-6-123B, a signal of intention to turn right or left or change lanes when required shall be given continuously for a time sufficient to alert the driver of a vehicle proceeding from the rear or approaching from the front. There's nothing in this warrant that suggests this police officer was approaching from the rear or approaching from the front. In fact, it is under my belief, and since it's not there, that this officer was stationary at the time he observed my client, which means that my client did not have any legal obligation to use a turn signal. There are not sufficient facts in this warrant to warrant an arrest or pulling the car over under OCGA 40-6-123 because there's been no crime committed, first of all. And second of all, under these, sorry?
I said, I understand, but go ahead. I won't get too far into the factual basis, but I will not dismiss that one at this point.
Okay.
Go ahead with your additional argument.
The additional argument is that there's no evidence whatsoever. First of all, this police officer, Officer Bacon, does have certification in roadside impairment and standard field sobrieties, but he is not a drug recognition expert, Your Honor. He has charged my client with exhibiting mannerisms consistent with someone under the influence of a stimulant drug. He does not state how being under the influence of that stimulant drug caused my client to be a less safe driver. This warrant does not meet the threshold of probable cause to suggest that my client committed a crime and is in custody for violation of a state statute. This officer is not certified drug recognition expert. There was no controlled substances found at the scene. There's no indicia that my client was using any type of controlled substances. And the warrant does not state how my client failed any standardized field sobriety test from an officer who in the warrant omits the fact that he is not a drug recognition expert. So under the facts of this warrant, Your Honor, I would move to that warrant also to be dismissed. I understand the court's propensity not to do that at this stage. And I would state in my place, Your Honor, that my client does not represent any type of danger to the community. He was on bond when he was arrested, but Judge, these warrants are awful thin. And there's nothing to suggest that my client has any type of a substance abuse problem, other than the fact that, you know, he may have needed to use a turn signal to change lanes. There's no act of less safe driving in this particular case. You know, if you were running down the road with something contraband in the car, I would understand the state's concern about, you know, alcohol awareness and safety and whatnot. But there's nothing to suggest that my client was operating a vehicle less safe as a result of being in the influence of anything. Obviously, the blood test will come back at that point. He was fully complying with the officer's command. The officer asked for a blood test. My client said, yeah, no problem. I'm not under any influence of anything whatsoever. And he willingly submitted to the blood test. My client has no history of not appearing for court appearances. He has a history of responding to judicial process. I represent him on the criminal trespass case. That's a very minor case. That's with Judge Dixon right now. We filed a motion to modify that bond condition. And I'll be representing him on this case going forward, Your Honor. He is in the infirmary. He has COVID. We're asking the court to let him out. He has family in the area. He has an ex-wife and two small children, ages 5 and 7, who live in Milton, Georgia. And he lives also in Milton, Georgia with them. He is not a risk to leave the community. And under the facts as stated by the state and based upon the affidavit for arrest warrants of this police officer, Judge, I don't see where revoking a bond or not admitting him to a signature bond would be adverse to the public interest, intimidate witnesses, or suggest that he's likelihood to flee the jurisdiction and not answer these calls to the court where there's no history of that, Judge. So this man is not a danger. He's more of a danger having COVID to other inmates than he is to anybody else. He needs to get out. He needs to get medical attention. I'm asking the court to let him sign on his bond on this particular case and have him released pre-trial, Judge.
Your Honor, just very quickly, I heard Attorney Salata say that the evidence does not support, but the rules of evidence don't apply to a bond hearing. I'm going based off of the warrant, and even though the warrant may be, it's not appropriate to dismiss at this time because we don't have the police report. We need to be able to look at the police report to see if they are in line with the statutes that he read. Therefore, the state is still asking for the 5,000 surety because, again, he was already out on a signature bond, which he does not know how to abide by the court's ruling and stay out of trouble when he's on a bond. And we feel as though $5,000 between both charges is appropriate. Nothing further from the state, Your Honor.
What was the state's request as far as was it 2,500 each, or what was the state's breakdown? I don't recall. Oh, I know. I had 4K on the first one and 1,000 on the other. I didn't know what the breakdown was. So what I'm going to do, Attorney Salata, because he is currently on a low trespass bond, I'm gonna do a split bond. And what I'm going to do with the split bond is the $4,000 on the DUI will be a surety bond. And then the 1,000 on the driving charge will be a signature bond through the jail. And so I'll split it that way.
Thank you, Your Honor.
And then no drugs, alcohol, or weapons while on bond. And that will be it. I'm not going to do anything about a course. But what I will say is if his license are suspended, you know, he needs to make sure of that, and no driving unless he has a valid license by DDS.
But his license is not suspended, Your Honor. I don't, and it was not, from what I understand, it was not submitted to the DDS because the blood test results remain pending. So usually in 1205 administrative section, you know, we'll deal with that with the administrative course. We'll send in a petition as a matter of course anyway, but he has a valid driving privileges, Your Honor, and certainly that would be consistent with him following, not violating the rules of any governmental unit, which I'm sure is part of the bond order in this case.
Okay. All right. Well, good luck to him. And that's the ruling of the court.
Thank you, Your Honor. I appreciate your patience.
All right.
Thank you, Attorney Salata.
Thank you.
I will send that waiver over now, Judge.
Okay, good. Because Ms. Lewis, you don't want her to be mad at you.
No, and I don't want to
Your
hold her
Honor,
up on Friday.
Is it the attorney or the attorney or the defendant that has to file the waiver?
The attorney.
Okay. Just
Yeah,
making sure.
he's gonna replace the one that was filed by Ms. Gant. That's fine.
Okay, sounds good. Thank you.
Coming at you now, Ms. Lewis. Thank you, Your Honor. Maybe.
All right, thank you. Have a good.
Also, Mr. Salata, if your client does not make bail, his next court date will be July the 21st on the SAP calendar, and that link will be sent to you. That's 2 weeks out if he doesn't make bail.
Thank you, Ms. Lewis. Appreciate it.
Thank you.
My pleasure, Your Honor. Thank you.
Thank you. All right, and do we have one more?
Yes.
Which is 14 bonded out.
Should be number 6.
6, that's it. 6 with the PD waiver. All right, this is 22 CR 004340D, Nazarene Davis, charged with willful obstruction of a law enforcement officer. Offense date April 24th, 2022. Pre-trial, you have anything?
Yeah. We got 36 cycles. He's here for a phase to appear for theft by receiving some other felony stuff. He got a theft by taking conviction from Bibb County, October 2021. September 2021, arrest for felony theft by taking. August 2021, theft by receiving. Tampering evidence conviction from 2020. He got more FTAs from 2019. Simple battery, simple assault, obstruction. 2019, giving false name conviction. 2019, probation, trespass. 2019, probation, obstruction, giving false name. You want more?
No, that's good. Thank you. Ms. King?
Yes, Your Honor. On April 24th of this year, the defendant was drinking from a wine bottle while on the train. The train was at the King Memorial Station at the time of this incident. The officer approached him and asked him for identification, and he complied. And while the officer was conducting a GCIC search, the defendant began to walk away. The defendant then exited the station via escalator and threw the wine bottle in the trash. The officer began to give chase, asking him to stop. The defendant at this time began to run and actually ran into the street and was also almost hit by a passing vehicle. At this time, the officer caught up with him and tried to grab him. He was unsuccessful, so sprayed him with OC spray, but the defendant still got away. And the officer was not successful in catching him. That is what this length of time is, Your Honor. The state is concerned about his criminal history. He has almost as many cycles as years alive, Your Honor. Multiple obstruction charges as well as convictions. He also has some violent convictions, a simple battery, armed robbery. He also has charges that speak with, I guess, alcohol and drugs. He has a DUI conviction, among others. For that reason, Your Honor, the state is requesting a $2,000 surety, a stay away from the King Memorial Station located at 377 Decatur Street. I would defer to Your Honor regarding him staying away from all of MARTA since he was on the train traveling at the time of the incident, and no drugs, alcohol, or weapons while out on bond.
All right, Ms. Gant.
Thank you, Your Honor. Mr. Nazarene Davis is 44 years old. He has been in the Atlanta area his entire life. He informs me that he has children, but they are all grown, but none of the children is available to help with bond. Mr. Davis completed high school. He also has 1 year of college in business management. He is unemployed at this time, Your Honor. Prior to his arrest, he was working at True Value Hardware. He does not have anyone to help with bond, and just, he denies the allegations, Your Honor. And based on the nature of the allegations, I would ask that Your Honor grant my client a signature bond. And if you determine that he is ineligible, then a bond of no more than $100. Thank you. And we are opposed to the stay away at any MARTA location unless there are active suspensions in place, Your Honor. Thank you.
All right. And how old did you say he was again?
44.
With 36 cycles, Your Honor.
Well, I mean, we did not hear of the number of convictions, and we would ask that you not consider arrests that have not led to convictions.
There are at least 15 convictions, Your Honor. I can count them out if you would like.
Nope, I will take notice, judicial notice. I appreciate that from the state. I'm going to order the $2,000 surety bond. No drugs, alcohol, or weapons while on bond. And I'm going to order for the time being a stay away from the King Memorial Station. I won't ban him yet from all of MARTA, but as we've been talking about in some of these other cases, I don't know if you all were on those other court dates. MARTA may already have his own ban, so he needs to probably check, or if you can check for him, Ms. Gant. But I'm going to put in my order he's banned from the King Memorial Station, 377 Decatur Street. But usually, if it conflicts with what MARTA says and they have a full ban, he needs to go by a full ban. So, Ms. Lewis, I'll put in there that I'm banning him from that King Memorial Station. However, if it conflicts with MARTA and MARTA has banned him from all of MARTA while the time he's on bond, then we'll go with what MARTA has done, so that we had another person that had gotten arrested thinking that, what they had from the court, which was less than what MARTA had. And I just don't want him to get caught up in between conflicting orders or conflicting ban versus an order, because MARTA will have the face recognition. He goes there, they'll see him and he'll be arrested. And he may say, well, I didn't know I was banned. I just knew that the judge ordered me not to go to that station. So, depending on what MARTA has done, and please find out for him, Ms. Gant, to help him, I will defer to what they have done if it is more extensive than my ban from the one station. Is that clear?
Yes, Your Honor. Thank you.
All right, thank you. Anything else, Ms. King?
Nothing from the state, Your Honor.
All right. That may conclude our cases, I think.
Yes, it is.
It sounds like you're saying it with a little bit of something there, Mr. Pretrial. Are you ready to start your weekend? We're going to let you go, or are you going to hang around for the
Hang
rest?
around. Monday will be here before you know it. So.
Well, we appreciate
all
that.
hearts and minds are clear. I'm ready to start the review of the calendar.
Yes, ma'am.
Please remember, when I say SAP, the reset date is going to be July the 21st, 22 at 9 o'clock.
Got it.
And any other ones is just reset further notice and return to the original judge assignment for that case. Position number one, I have a $5,000 split bond, 4,000 surety, 1,000 SOB through the jail. Position number 2, defendant was released. The case is reset further notice. Position number 3, I have a 4,500 SOB through pretrial. Number 4, I also have a $2,000 SOB through pretrial. Those are reset further notice. Position number 5, I have an $8,000 surety bond. That's reset for SAP. Position number 6, I have a $2,000 surety bond reset for SAP. Position number 7, I have a $3,000 SOB through pretrial, reset further notice. Position number 8, I have a total of a $10,000 SOB through pretrial, reset further notice. Position number 9, I have a $4,000 surety bond, reset for SAP. Position number 10, I have a $3,000 SOB through the jail, reset further notice. Position number 11, I have a 2,500 surety bond, reset for SAP. Position number 12, I have a $500 SOB through the jail. Position number 13, I have a total of a $3,000 split bond, $2,500 good bond on the first charge and $500 on the second charge, SOB through the jail, which that case is going to be reset for the SAP counter. Position number 14, defendant made bond release, reset further notice. And position 15 is a $2,000 surety bond, reset for SAP. All minds, hearts are clear. Any corrections or comments?
Nope, not by me. Anyone else? All right, everyone
No.
have a good weekend. Sorry.
No, I said no.
Oh, no, have a good weekend, pre-trial.
Okay.
All
And Judge, I
right.
get those orders to you immediately.
Thank you, dear. All
And Ms.
right,
Duncan, I did get your corrections on your transfer order.
good.
Okay.
You
All right.
sent me another one. Don't sign this one.
No, no, Sam, you can send that one. It was just a name. It was just a
Okay.
name order. I
Good.
corrected it when I saw it when I got the first go around.
Okay. All right. Thank you.
All right, thank y'all.
All right. Bye-bye. Have a good weekend.